Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session.
Fix this. Fix my seat. Okay. Good morning, everyone, and welcome. We're very pleased to have you with us this morning. We have 3 cases on the docket, and we will call them in the order in which they appear. I'm very pleased to announce what you should already know is that Judge Jeffrey Usman took his oath of office last week, and his first official day as a judge of the Court of Appeals of Tennessee was Thursday, and he sat yesterday, and so we are working him as hard as we possibly can, but he's excited to be here, and we are excited that he has joined our court. You have obviously noticed the monitor on the bench this morning. I'm pleased to announce that Judge Neil McBrayer is healthy and doing well, but he tested positive for COVID a few days ago, and while he is past the required quarantine period, out of respect and concern for the welfare of all, he has chosen, and with my encouragement, to participate remotely. So he will see and hear everything that happens in the courtroom today, and I'm sure he will have some bone-crushing questions to ask of you. And so just be mindful that Judge McBrayer is just as active in the hearing this morning as he would be if he was physically sitting in this chair. Each side has 15 minutes to argue. The appellants have the option of reserving up to 5 minutes for rebuttal. If you choose to do that, please announce that at the beginning of your argument so the clock can be programmed accordingly. Are there any announcements? Hearing none, please call the first case.
Cierra Besses versus James Killian.
Good morning.
Good morning. May it please the court, I'm Shelley Breeding of the Knoxville Bar. I would like to reserve 3 minutes for rebuttal, please.
Very good. We'll program the clock accordingly.
Thank you. This appeal arises from a car wreck that occurred on September 14th, 2017. James Killian, the appellee, rear-ended Cierra Besses, the appellant, causing Besses to suffer a bruised right knee with repeated swelling and bruising, a neck strain, a lower back strain, and a concussion. Besses then developed chronic migraines because of the accident. Besses sought treatment with her primary care physician, Dr. Moulman. Also, she sought treatment with Dr. Singh, an orthopedic at Vanderbilt Medical, and Dr. Clark, a neurologist at Vanderbilt Medical. Dr. Clark opined that Besses suffered from post-traumatic headaches and migraines that were caused by the accident. He also testified that, quote, she will have continued symptoms for the foreseeable future and will likely require at least some degree of medical follow-up for these issues. That follow-up could be lifelong, but would be months or years at the least. Killian offered rebuttal testimony from Dr. Graham. He opined that Besses' headaches were tension-type headaches, most likely, even though he had never interviewed or seen Besses, and that Besses' headaches could persist into the future. He also opined Besses should continue to receive the care that she was then currently receiving. The jury heard the case June 21st and 22nd of 2021, and the jury returned an award for Besses with $12,720 for medical expenses, past physical pain and mental suffering of $3,000, past enjoyment of loss of life, $1,000, but the jury did not award any damages for future physical pain and suffering and did not award any damages for future loss of enjoyment of life. The trial court then entered a judgment affirming the jury's award. Besses' trial counsel filed a motion for adjudicature and/or new trial on July 6th of 2021, and the trial court denied that motion. All the issues for appeal involved the trial court's entry of the jury's award that was not supported by the evidence, and the trial court's failure to award a new trial where the jury's verdict was inadequate and not supported by material evidence. The trial court acts
Counsel,
as...
would you agree our review in terms of the issues you're raising is fairly limited here? If there's material evidence on the record to support the jury's determination, then it's the responsibility of this court to uphold that decision by the jury.
I generally agree. The standard of review when the trial court approves the jury's verdict is whether there's any material evidence to support the verdict.
Isn't there material evidence in this case in the form of questioning that relates to whether the symptoms in this case are fully derived from the accident or may be caused by stress from being a college student? And isn't there something, maybe you had the better evidence, but isn't there evidence on the record the jury could have looked at and said, for example, Ms. Besses said the car accident occurred at 50 miles per hour that she was hit, and that was part of the physician's decision in terms of where these symptoms are coming from, but there's evidence that maybe it wasn't actually 50 miles per hour when she was hit.
I understand that there's that contrary evidence, but I don't think there's any contrary medical evidence, and even Dr. Graham testified that her expenses were reasonable and necessary. We filed our appeal on 3 different issues, and first being...
I thought that doctor said some of the expenses were not justified.
He opined that he was not sure. Let me go back. First, he said, regarding the past medical expenses, he was asked on page 10, I believe, of his transcript, quote, the question was, quote, the bills or records that were provided to you, were they reasonable and necessary for treating the plaintiff? And his response was, yes, they found those to be medically necessary related to the 9/14/17, end quote. And that was his testimony at the very beginning of his testimony in the deposition transcript that was filed as an exhibit. At most, he contested a very small amount of the medical expenses. There was a physical
examination.
There was a physical exam with some related blood work, and he stated he did not know whether the physical exam was related to the accident, and that those fees, quote, would not necessarily be related unless there was discussion and treatment provided, end quote. And again, that's on page 10 and 11 of his testimony. But those expenses only amount to $1,642 of medical expenses. Besses put on proof that she incurred $17,045.73 in medical expenses. The jury awarded her only $12,720.
Counsel, wasn't there testimony in this case, though, that the doctors are heavily dependent? There's not a sort of scan that shows migraine caused by car accident. The doctors are heavily dependent upon self-reporting, what Ms. Besses said happened, what she said she was experiencing. Isn't there evidence that has been raised by the defendant that to question whether it's really all caused by this accident?
There were questions about it, but Dr. Clark opined that those headaches were caused by the accident. Dr. Graham had never seen her. He said that they could be a different type of headache, but certainly she was experiencing headaches and would likely continue to experience the headaches and would need future medical care for that. I think this case is analogous to the Naragian v. Wilson case out of the Western District. In that case, the Court of Appeals vacated the jury's award of a verdict and remanded the new case for a trial on all damages because, quote, there was no evidence rebutting the necessity or reasonableness of the charges billed. The court there discussed the Taylor v. Smith case that stated because we found no material evidence to support an award less than the hardcore medical bills, we were compelled to vacate the trial court's judgment entered on the jury's award. It's the same thing in this case.
In this case, isn't there evidence that her complaints could be caused by for other reasons, not involved in the trauma?
That was not Dr. Clark's testimony, I don't believe. I think Dr. Clark opined they were from the car accident. They were causally from the car accident.
I thought there was testimony that the migraines could be caused by a plethora of things that have nothing to do with the car wreck.
He said migraines in general could be caused by a plethora of things, lack of sleep, I believe use of alcohol, hormones.
So isn't that evidence that is material to the question of what damages she sustained and what medical care she should tie to the accident?
It could be, but in this case, he said, as her treating physician, that he thought her headaches were related to the accident. Regardless of that, there was no rebutting testimony about the reasonableness of the medical expenses, and certainly not anything that would reconcile with the jury's award that was $4,315 less, when their only rebutting proof from Dr. Graham was about the physical exam and the blood work that was only $1,642 less. There's nothing to reconcile, there's no material evidence to reconcile the jury's award of how they came up with the amount that they came up for.
Counsel, in terms of the future damages aspect of this case, the physicians didn't impose any limitations, correct? And there's no sort of, she's limited in this way, she can't engage in this activity. From her treating physicians, there's no set limitations, right?
Correct. That is correct. The physicians said that, but the physicians also said that there would be future medical expenses. Dr. Clark said that he would need to continue seeing her for the foreseeable future. Besses testified that she had an appointment with him in about 6 months. She testified she had a follow-up appointment with her primary care physician in the fall. Even Dr. Graham said that she would continue to need medical care and should continue to receive the care that she was receiving for her headaches. There was no material evidence presented that she would not need future medical care in this case. Yet the jury awarded $0 for future medical expenses. Killian conceded that she would have continuing medical expenses. Graham testified that some individuals who have post-traumatic headaches that may last sometimes many, many months, end quote. And that's Killian's own expert saying that this would likely continue in the future. There was no testimony to support an award of $0. Dr. Graham did not say in any way that she would not need any medical treatment in the future. Perhaps there's no limitations on her, but that doesn't mean that she doesn't still need medical care and would incur medical expenses, even if she's still able to work and go to school and drive and those things. It doesn't negate the need for future medical care. Our third issue that we presented was the jury's award of $0 for future loss of enjoyment of life. As this court in Overstreet stated, damages for loss of enjoyment of life compensate the injured person for the limitations placed on his or her ability to enjoy the pleasures and amenities of life. The court went on to find that type of damage includes damages for common life activities as well as uncommon activities. And this court cited to a string of cases that involved things like not pursuing a particular career or not being able to do ballet. Besses testified that she's prohibited from and restricted from doing many things that she devoted her life to. Before this accident, she was very active and dedicated her life to jazz, ballet, tap dance. She was also able to play basketball and piano. She even planned on auditioning for the Radio City Rockettes. These events were extremely important to her. She attended Belmont University, a music business major with a minor in dance, and that's what she planned on doing for her career. She was at the peak time of performance. At the time of the accident, she was 26 years old. At the time of trial, she was 30. For a dancer, those are very important years for her damages. The jury awarded $1,000 for past loss of enjoyment of life, yet Besses's past loss of enjoyment of life was remarkably similar to her future loss of enjoyment of life. And the jury awarded $0 for the future loss of enjoyment of life. It's simply irreconcilable how the jury came up with $1,000 for the past loss of enjoyment of life, yet awarded no damages for the future loss of enjoyment of life. Finally, we ask if the court awards a new trial that the court also address the trial court's award of discretionary cost. There was an offer of judgment, and the trial court awarded a portion of discretionary cost to the defendant based on that offer of judgment. And if this court awards a new trial, that award of discretionary cost also be set aside. As the Tennessee Supreme Court in W.T. Grant Company versus Tanner stated, it's quite generally held that if from the inadequacy of damages awarded in view of the evidence or the conflict of evidence upon the question of liability, or from other circumstances, plain inference may be drawn that the verdict is a result of a compromise. A new trial should be ordered upon all issues. And the Naragian case, very similar to this, the court did just that and awarded a new trial on all issues. And we ask this court to do the same.
Thank you. We'll hear from you further on rebuttal.
Thank you.
Good morning.
May it please the court, my name is Michael Becker, and I'm the attorney for appellee, or the defendant, James Killian. Defendant asserts that the jury's verdict of $16,720 and all subparts of that total verdict were supported by material evidence. And as such, the trial court was correct in denying plaintiff's post-trial motions for adjudicature or new trial and the pro se motion to set aside. And defendant asked this case be affirmed on appeal. During my time with the court this morning, I'll try to briefly cover all of the issues for review, including medical expenses, future physical pain and mental suffering, future loss of enjoyment of life, and court costs. I'm going to spend a significant portion of my time on future medical expenses. Just in general, as the court knows, an appellate court will not disturb a jury's verdict that is approved by the trial court if there is any material evidence to support the verdict and award. In this case, plaintiff had two expert witnesses that were called at trial, Dr. Singh, who was an orthopedic, and Dr. Clark, who was a neurologist, as well as fact witnesses, plaintiff's mother and plaintiff herself. Defendant presented an expert witness, Dr. Stephen Graham, a neurologist, and two fact witnesses, Pam Porter and defendant. Defendant provides in his brief some relevant portions of the testimony that we believe support the verdict. Quickly run through a couple of these for your honors. Dr. Singh, plaintiff's neurologist, testified that plaintiff reported no loss. Can't remember. Dr. Singh is her orthopedic. I apologize. He testified that plaintiff reported no loss of consciousness and no heating of her head in the accident. He further confirmed that there was no treatment until 9/24/17, which was 10 days after the accident. And that he had testified that it was common for cervical strains to completely heal, and that's what happened in this case, and did not assign any permanent restrictions. He found that plaintiff's MRI was negative and had not seen plaintiff in over 2 years. Dr. Clark, plaintiff's neurologist, testified that headaches are largely subjective, if not all subjective, and that there is no objective test for a headache. He did not see plaintiff for the first time until over a year after the accident. He also confirmed and testified that there's a number of different causes for onset of migraines and headaches. Plaintiff herself testified that she left the scene of the accident driving her own vehicle, and the defendant also left driving his own vehicle after the accident.
Counsel, is there evidence in the record that those other causes are applicable in this case? So the doctor says it could be stress that causes the headaches, not the auto accident. Is there evidence in the record to support that Ms. Besses was suffering from stress?
That's an excellent question. Pam Porter, defendant's witness, who testified she was a doctor of natural medicine, but the important part for her is plaintiff filled out a client profile on September 15, 2017, the day after the accident. In that profile, plaintiff indicated that she was under stress from school and work and sometimes lack of sleep. There was nothing about a motor vehicle accident on the client profile. I think that's the extent of some of the testimony as to other causes, other than the doctors testifying that there are many different causes for headaches, and largely it's unknown why you have headaches. Dr. Graham testified that there was no documentation of any anatomical derangements on the images, and that the cause of these tension-type headaches is not exactly known. Lack of sleep, dietary causes, other factors, including hormonal changes, can also influence headaches.
Counsel, one thing I'm struggling a little bit with is the future medical expenses, which you said is going to be. So I may be cutting you off where you're heading.
You're just a step ahead of me, Judge. But you're exactly right. That was what I will turn to next.
It seems like your argument is, and maybe I'm mischaracterizing, and correct me if I am, but that there's a causation issue in terms of material evidence, that you've presented evidence that there are other causes than the accident in terms of what's leading to these medical expenses. Let's say that's correct. How does that translate into future medical expenses? If some portion of the causation here is attributable to this auto accident, isn't some portion of the causation also attributed for purposes of the future medical expenses?
Well, here's what happened with the future medical expenses. Future medical expenses doesn't appear on the verdict form. There's no line for it at all for future medical expenses. There's some mention in plaintiff's brief about future medical expenses must have been lopped into future physical pain and mental suffering or future loss of enjoyment of life. I don't think that's correct. What happened here is that the trial court correctly determined that plaintiff had not presented sufficient evidence on future medical expenses, and as such, that issue did not go to the jury. And here's the analysis as I believe is appropriate.
Did the plaintiff make a timely objection to that trial court's decision?
Well, what happened, Your Honor, is that after plaintiff closed the proof, there was a discussion in the record on volume 4, page 205 through 207 about future medical expenses. And the trial court found and held on page 207, and this is the court, and the case law says it doesn't have to be exact, but they can even do an estimate, and they can go to the jury, but he didn't. He didn't put a number at all. So I think future medical has not been proven by the medical proof, and it takes medical proof to do that, future medical expenses. And what the trial court's talking about is you don't have to have an exact amount of future medical expenses, but you have to give some kind of estimate or something for the jury to base their decision on future medical bills. And where he gets that at, or the trial court gets that, is from the case law we know, and there is that future medical expenses may not be awarded when the damages are based on speculation or conjecture. And what I'm looking at here is Curry versus Memphis Light, Gas, and Water, a 2019 Court of Appeals of Tennessee case written by Judge Bennett. And in that case, it says, in order to prevent an award of future medical expenses from being based upon speculation, a person seeking such an award must present evidence of the following. And it's a two-prong requirements. First, that additional medical treatment is reasonably certain to be required in the future. I think that was met in this case. All right, the second prong is what the trial court found was not met, and I think rightly so. The second prong is that the evidence will enable the trier of fact to reasonably estimate the cost of the expected treatment. And so what you have to have is there may have been some treatment from Dr. Clark about her needing future treatment, but there was no treatment from Dr. Clark or Dr. Singh about the cost of that future treatment, estimate as of that future treatment, nothing in that at all. Dr. Singh, in fact, said she wouldn't need any more treatment, hadn't seen her in 2 years. Dr. Clark talked about some follow-up treatment, but there was never any treatment about the reasonable cost of future medical treatment or a reasonable estimate of cost. So there was no evidence as to that. And that's what the trial court found was the second prong of the required proof, that evidence that will enable the trier of fact to reasonably estimate the cost of the expected treatment. That part wasn't met. It was discussed at the close of plaintiff's proof. That was the court's ruling on page 207 of the transcript. There was no further discussion on future medicals. Future medicals was not on the jury verdict form. Plaintiff in the post-trial motion for adjudicature or new trial, or in plaintiff's pro se motion to set aside, did not bring that back up. And that's really the extent of the future medicals. It's kind of an interesting case because I know appellant's counsel and I, neither one of us tried the case, and the first appeal that I have had where I was not the trial lawyer. So it was interesting to go back through. I felt that going through sort of put me in a position of how the court looks at it, of not having the experience, but being there. So I went through all of the transcript looking for any discussion, and that was it. I can tell you the other discussions about on the record about when it went through jury instructions and jury verdict form, there was no objection on there either. At that point, the court gave the jury instructions and the verdict form to counsel. There was no objections, and then went through all of that with the jury. And so future medicals didn't appear on the jury verdict form, and the court explains on 207 why. The final two issues that we're talking about is future physical pain and mental suffering and future loss of enjoyment of life, where the jury awarded $0. Now, the jury did award $3,000 for past physical and mental suffering and $1,000 for past loss of enjoyment of life. And it is the defendant's position that this shows the jury considered the different categories of damages and made a determination the plaintiff was not entitled to recover for future damages. They made credibility decisions that it was their discretion and their right to do.
What do you say about the past damages? Counsel, Ms. Breeding, mentioned that there was a $4,315 difference in what the evidence she presented and what the jury awarded.
Yeah, I think that I would just go to the jury's not bound to accept any expert witness testimony. They made credibility decisions as to what they believed was related and not related. And just because it was presented doesn't mean the jury has to award that amount. That's where how they came up with the $12,720. We don't know for sure how that came about, but that is the arrangement that we have. That is what the juries did. They made credibility decisions, and they just didn't believe that part of the medical expenses were related the same way they didn't believe that plaintiff had any future pain and suffering.
So the jury didn't award a round ballpark figure. They gave a specific amount.
Yes, sir. That's
something $20.
Yes, sir. $12,720 on the medical expenses. And so it was just our position that the jury made credibility decisions based upon seeing the testimony of the witnesses and use that testimony and that credibility to make their determinations. It can tell that the jury, by awarding different amounts for past and not for future, were consistent in what they were awarding. And we feel that the jury's verdict is supported by material evidence as outlined in pages 8 through 21 of defendant's brief. The last issue on court costs, the court, it is correct. What happened was an offer of judgment was made by a defendant on August 7, 2019. The jury verdict was less than the offer of judgment, and the trial court then ordered that plaintiff pay court costs from the date of offer of judgment to the end of the trial. There wasn't any kind of discretionary cost awarded, none of that. It was to pay court costs from the date of offer of judgment to the end of trial, and I believe that was within the trial court's discretion to do that, and we'd ask that to be affirmed as well. In conclusion,
let me ask you,
yes, sir.
You do not dispute the award of discretionary costs unless they're unless we reverse or modify it.
Correct, yes. Yes, sir. Defendant respectfully asserts that the jury's verdict was supported by material evidence and the trial court was correct, and within its discretion in its ruling on plaintiff's post-trial motions, and defendant requests this case be affirmed.
All right, thank you, sir. Ms. Breeding, your rebuttal. And I'll ask you the same question. I fully understand that if we should agree with your broader argument that you should have a new trial, the discretionary cost award should be set aside. But absent that, you have no objection to the amount of discretionary costs.
Correct.
Okay, thank you.
Correct. It's only if there is a new trial that part should also be set aside to be addressed. I think counsel's correct. There was not a separate line, and as he noted, neither of us were trial court counsel in this case. There was not a separate line for future medical expenses, but I also think the trial court erred in that regard. As the court has said—
Would not a timely objection be necessary for us to consider that on appeal?
I think at the trial court level, the court made that decision after an argument. I don't know if there'd have to be an objection when it was brought up and argued at the trial court by trial counsel. I don't know if there was anything to object to when defense counsel made the motion. I don't know if there was a response to it. I don't know if there was an objection required. Damages cannot be mere conjecture or speculation, as Appellee's counsel noted. However, uncertain or speculative damages are only prohibited when the existence of, not the amount of damages, is uncertain, and that's from the Overstreet case. And in this case, the existence of was not uncertain. I think everyone agreed that she needed continuing medical care. The amount of may have been uncertain, but the only thing that was required was to provide some proof to allow the trier of fact to reasonably estimate the future medical cost.
So with regard to the future medical cost, is there development of that? I'm trying to recall the briefing in this case. Is there development of argumentation in the briefing that the trial court erred as to not putting that before the jury, the specific question of future medical cost?
Yes, I think the trial court did err in not having that specific line item.
In terms of the appellate briefing in this case, though, is there? I'm not recalling that from the briefing. I may just not be remembering it. But is there a specific argument made that the trial court erred as a matter of law in not putting that specific question to the jury?
I think we addressed it in our overall second issue that it was error to award Besses $0 for future medical expenses. We noted that it was unclear whether the jury had assessed future medical expenses as part of the medical expenses or part of the future physical pain and mental suffering category. I don't know that we brought it up as a separate issue, but we did address, it was unclear on the jury verdict form how they addressed that as part of our second issue, and that was on page 24 of our brief. Again, I think the main issue here is they had the past and they could consider the future medical expenses from that. And additionally, the other damages for loss of enjoyment of life and past physical pain and suffering are simply irreconcilable with awarding $0 for future damages in those amounts. So we would ask the court to vacate the trial court judgment and remand for a new trial on damages of all issues.
All right.
Thank you.
Thank you, Ms. Breeding and Mr. Becker, for your arguments, and we will take this matter under advisement. Call the next case, please.